Thanks very much, and thank you, David, and thanks to Richard for inviting me for the first time to Richmond. It's been very pleasant to come here. Like the kit before lunch, I feel very much that in the audience are people who've worked on this question much more than I have, and I'm very keen to get their comments. It doesn't seem to them too amateurish. I think those of you who may know this, Isaiah Berlin once drew a famous contrast between hedgehogs and foxes. Hedgehog knows one big thing, fox knows many little things. I've also, in some ways, more illuminated possibly to contrast the mole and the vulture. So the mole is among sort of political philosophers. The mole is somebody who very doggedly pursues one line of inquiry, very deep and very thorough. The vulture sort of hovers around and sees an interesting little bit of carrion over there, and sort of swoops down and seizes upon it. I'm afraid that's me. So I'm always sort of more interested when I find an issue that I don't know what I think about, which partly explains this terrible sounding CV that I have with all these different topics having been addressed. So this is my first try, and in fact it comes much closer than I usually want to come to the L part of the PPEL, the law part. It does talk a bit about punishment. Okay, and the PowerPoint is horribly amateurish. It's very crude. Here's the problem. We usually think of human rights as attaching unconditionally to all human beings. You have them simply by virtue of being human without having to do anything special to be awarded them. Different theories about why you have those rights, but they're supposed to be universally shared. And they're often also said to be inalienable. They're not things that a person can lose by virtue of the way that she acts. So take those two thoughts together. They amount to the claim that human rights are unconditional. They don't have to be earned and they cannot be alienated. Well, that's how we regard human rights in theory, but the practice seems to be different. We act in ways that deny people at least some of their human rights, and we claim to be justified when we do so. In particular, we wage wars in which people are killed and wounded, violating their rights to life and to bodily integrity, and we punish people by imprisoning them, seemingly violating their right to freedom of movement, as well as a whole host of others. Now, some people might say that neither of these practices therefore can be justified, but much more commonly it's thought that under the right circumstances, wars can be just, and so can custodial punishments. And so we seem then not to believe, after all, that human rights are unconditional. Either they can be lost entirely, or at least there are circumstances in which they can easily be overridden. So that's the problem. How can we announce in our manifestos that human rights are unconditional, and yet in practice, when we fight wars and punish criminals and so on, we seem to be seeing them as conditional? How can we reconcile these two positions? Now, my interest in this was provoked by two particular contemporary issues that led me back to a famous philosophical text, Locke's Second Treatise of Government. The first issue is a bit parochial and concerns the still unresolved argument between the British government and the European Court of Human Rights over the political rights of prisoners. So historically, following the 1870 Forfeiture Act, British law has denied all convicted prisoners the right to vote, and that blanket ban has been challenged by prison inmates appealing to the European Court, and the courts insisted that on human rights grounds the ban must be lifted. Its complaint is about the indiscriminate nature of the ban. It will be satisfied if removal of political rights was contingent upon investigating individual cases. So here it seems that both sides, both the government and the court, accept the principle of forfeiture of political rights, but they disagree about what must be the case for that forfeiture to be justified. But nobody, I think, has really tried to explain how this idea is supposed to work, which human rights may be forfeited, and under what circumstances. So that's the relatively, as it were, parochial issue. A much more momentous issue is about the way that liberal societies respond to those engaged in terrorist activities. So, for example, may they preemptively kill those who've been identified as potential suicide bombers? May they intern terrorist suspects without trial? May they torture known terrorists to gain information about forthcoming attacks? Any of those responses involves violating some of the most fundamental human rights of those individuals, but it's often said if you engage in a campaign of terror, you lose the protection of those rights. So if indeed it's necessary to do these things to protect innocent citizens, then it's said it's not wrong to do it. So those are the questions that took me back to these passages in Locke, where he seems to say that human, or as he would say, natural rights, are indeed conditional. And those passages are those in which he's explaining how we may respond to those who've harmed us or who approach us threatening harm. And this category of persons may include enemies in war, common thieves, political tyrants. In all these cases, Locke claims, somebody who by virtue of his aggressive conduct ceases to acknowledge the rule of reason loses his status as a rights-bearing human being and may be treated in the same way as a dangerous animal. So here, for example, I'll just put up a passage in which Locke explains the basic idea of aggressors forfeiting rights by putting reason, announcing the way of peace. They revolt from their own kind and render themselves liable to be destroyed both by the injured person and the rest of mankind. And that idea that the aggressor, by his actions, leaves human society and joins the beast is repeated in a number of places in the book. It may be destroyed as a lion or a tiger. For the same reason you may kill a wolf or a lion. So only a few animals that get mentioned, but they keep getting usually the same ones: lions, tigers, wolves, these kind of animals. This seems to be a consistent theme in Locke's work. Now, that may give the impression that what Locke, this animal analogy, that he's holding what we can call a strong forfeiture view. That once somebody embarks on the unjust use of force against another person, he immediately loses all of his rights. But in other cases, he's careful to distinguish between the rights that the aggressor loses and those that he doesn't. So when an armed robber threatens me on the highway, I'm entitled to kill him if that's necessary to protect myself, but I'm not entitled, if I can overpower him, to steal his possessions. So the robber forfeits his right to life through the unjust use of force, but not the right to property. So now it might begin to look as though what Locke is giving us is not a theory about the wholesale forfeiture of rights, which is what the lion and tiger passages suggest, but a theory of self-defense. Attacker loses his right to life because I have the right to defend myself against the attack, but other rights that are irrelevant to the threat are retained. But that's not right either, because Locke clearly intends the forfeiture view to justify punishment after the event, as well as self-defense at the time of the aggression. And punishment is not the same as self-defense. It's inflicted at a point where typically the aggressor no longer poses an immediate threat. And there's a second reason, which is that Locke sees aggression as an offence against humankind generally, not just against the person who's its direct object. That's why other people too can punish the wrongdoer. So now the question is, how, according to Locke, are rights forfeited. So these rights attach to people by virtue of their capacity to reason. And in the background, there's Locke's claim that anybody in whom that capacity hasn't been impaired is able to grasp the laws that God has laid down for the guidance of mankind. And these, in broad outline, tell us, here's a little quote, that all being equal and independent, no one ought to harm another in his life, health, liberty, or possessions. So these laws confer rights that protect these basic goods, life, health, and so forth. But they do so on a reciprocal basis. A necessary condition for holding rights is that one should be guided by the natural law, the rule of reason, when you interact with other rights holders. Now clearly an aggressor, somebody who attempts to kill or injure another, or enslave them or rob them, breaches the natural law when he so acts. But it's not clear why a single breach should change the status of the aggressor in such a way that he's no longer a right holder. Locke's argument, it turns out, proceeds by a series of inflationary steps. We begin with an act that violates another's rights, an attempted robbery, say. Locke then argues that a person who's willing to act in that way demonstrates that he's also willing to violate the victim's rights more generally, to the point of killing him. That's then treated as equivalent to a declaration that the aggressor doesn't recognise the common law of reason applying to himself. And that in turn is treated as a declaration of war upon mankind at large, not merely on a particular victim. So that's why the person puts himself into the category of those noxious creatures, the wolf and the lion, the enemies of mankind. Now once the argument's laid out in that way, there are two immediate difficulties. The first is that each individual step seems unjustified. We've no reason to regard every robber as a potential homicide, for example, nor does breaking a rule on one occasion amount to an announcement that one doesn't recognise the rule's authority at all. Second difficulty is that the argument seems to entail that the criminal forfeits all of his rights, whereas Locke himself, when he discusses the right to punish, makes it clear that punishment must be proportionate to the offence and no greater than is necessary to achieve the two justifying aims of repentance and deterrence. But why would punishment that oversteps those limits be unjust unless the person on whom it's inflicted retains some of his rights? So it seems then that Locke's rather striking account of the conditionality of human rights is not only harsh in its implications, but also inconsistent with his more considered views about property rights and punishment. So the issue then is, can it be rescued? Well, why might we want to rescue it? What drew me to Locke's view, first of all, was the sense that there's something right about the idea that human rights depend upon reciprocity. Our possessing them is conditional on our willingness to respect them in others. So it then seems to follow, as Locke suggests, that somebody who knowingly violates the rights of others without good reason forfeits his claim to have his own rights respected. But as we'll see, many people have thought that idea of forfeiture collapses under closer scrutiny. So before we follow the sort of forfeiture trail, let me just explore some other ways in which we might try to reconcile the idea of inviolable human rights with practices like judicial incarceration. I think these are the sort of responses. I've presented this to people, presented the initial problem to people. Many of them instinctively respond in one, I think, of the following three ways, and here they are. So, first of all, according to some people, when we engage in practices like imprisonment, we simply allow human rights to be overridden by wider goals, by, for example, the need for a mechanism that deters people from attack and protects society in that way. So there's no question of prisoners losing human rights. The rights are simply set aside for the greater good of society. You might try and make a similar argument about, for example, war or justified war. But I think that solution seems to miss one of the basic points of attributing rights to people in the first place, which is that they create a kind of protected zone for each individual, which states can't enter in their pursuit of wider social values. They're supposed to be a serious matter. They're supposed to constrain governments. But if you could override prisoners' or soldiers' rights merely by pointing out good consequences of doing that, all of that purpose would be lost. We wouldn't be taking rights seriously. So what about the second approach? Well, this says human rights all have scope limitations built into them, and the suggestion is that when we punish criminals, we're simply enforcing those limitations. Now, the premise is right. When we determine the scope of a human right, like freedom of movement, for example, we have to do it in such a way that the equal rights of others are recognised and protected too. So, for example, traffic laws or crowd control measures don't normally violate the human right to free movement. What they do, if they're well designed, is precisely to limit my right to move in order to make sure that you can enjoy a right of equal scope. More generally, I think, and one can sort of say the same thing about different rights, the scope of any particular human right must be limited in such a way that its exercise doesn't impinge upon the appropriately limited scope of others. But though the premise is right, the conclusion doesn't follow, because the practices we're concerned with do far more than enforce the proper limits of human rights. A person sent to prison, his freedom of movement is restricted in a much more radical way than when traffic laws or the riot police prevent him from exercising that right to the detriment of other people's. I mean, it's true that when he's locked up he can't go around violating rights, but it's really a case of sort of overkill from that point of view. So I don't think the second suggestion is going to work either. Now, third suggestion involves drawing a distinction that's become familiar between infringing rights and violating them. And the underlying thought here is that sometimes it's necessary to breach one right in order to protect another right of greater importance. And when that happens, the right that's breached isn't violated, but it's merely infringed. And the sort of cases that are used to illustrate that often involve life and death situations when one person, to save her life, has to infringe some lesser right of another person by, for example, taking that person's property or injuring them. But I think you can also argue that cases of self-defense can be interpreted using this infringement violation distinction by introducing the idea that rights have different degrees of stringency. So justified self-defense occurs when the defender's right to life is more stringent than the corresponding right of the person who poses a threat. But again, I think the problem here is that this doesn't really work in the case of imprisonment, because if we're going to say that prisoners' human rights are not violated but merely infringed when they're locked up, we'd have to show that the incarceration is a necessary means to preserve somebody else's more stringent right. And that's going to be difficult, except perhaps in the case of exceptionally violent convicts whose relief might pose an immediate threat to other people's rights to life and bodily security. It won't apply to the ring run of criminals. So it begins to look as though if practices like imprisonment are going to be justified, we can't do it unless we're willing to take on board and take seriously the idea of rights forfeiture. So we've got to explain in what sense rule-breaking agents forfeit their rights, people who contravene the blocking rule of reason forfeit their rights. And we also have to explain which rights they forfeit and which they don't. Because I think we want to avoid that stark view that seems to be there in Locke, that criminals of all kinds, robbers as well as murderers, remove themselves from human society and join the beasts, losing all their human rights in the process. We want to avoid that view. But then we've then got to explain how it is that by acting in a certain way, you can lose some of your rights, but still retain others. So, how are we going to understand this idea of forfeiture? So the idea, I think, the underlying idea, is that a person enjoys the protection of human rights so long as she acts in ways that respect the human rights of others. And when she fails to act in those ways, she loses that protection. So other people, including those she's victimised, no longer are under the duties they would otherwise be under to respect her rights. Now that doesn't mean, let's notice, that she loses any claim to the substance of those rights. There's always a logical gap between having a right to something, let's say food, and having a claim to that same thing, because claims can be advanced on other grounds as well. So if somebody forfeits his right to food, what that means is that other people no longer have a right-based duty to ensure that he has food. It doesn't mean they have no reason to feed him. It certainly doesn't mean that they have a reason or a duty to actually deprive that person of food. So forfeiting rights, let's say, is not the same as abandoning all moral claims against others in the relevant domain. There's another error here, I think, that has to be avoided, and that's to understand forfeiture in such a way that it becomes merely a matter of convention. So, for example, in the context of games, the idea of a forfeit is that somebody who breaks one of the rules has often to do something ridiculous in order to redeem their forfeit, where the forfeit is just sort of written into the rules of the game, and it's just a matter of convention. And so critics argue that in criminal law, the idea of forfeiture can't play an independent justifying role, because what a person forfeits by his crime is simply whatever the prevailing law lays down as the appropriate penalty. So if law says that murderers shall hang, and what a murderer forfeits is his right to life, if instead the penalty is life imprisonment, then the killer forfeits his right to freedom. But then we can't, if that's the way it's understood, we can't appeal to the idea of forfeiture to explain why one or other of these punishments is the appropriate response to what the murderer has done. So that's not going to help us if what we want to use forfeiture to do is to make sense of the idea that by acting in a certain way, you can lose some but not all of your rights, when exactly which rights you lose is precisely what's at issue. There's yet another full step, third bullet point, which is to suppose that what's forfeited is the exact equivalent to the right that the offender has violated. So this makes forfeiture equivalent to retribution, to the idea of an eye for an eye and a tooth for a tooth. So simple retributive view says that whatever an aggressor has done, the same should be done to him in return. But that's not the kind of reciprocity I had in mind when I was arguing that it could be used to explain the idea that human rights are conditional. As I say, the idea is that when rights are forfeited, Others are released from duties that they would otherwise have been under, but that doesn't by itself give them a reason, let alone a duty, to penalise the forfeitor. So forfeiting rights may entail that certain forms of punishment are permissible, but it doesn't entail that they're required, or that justice is served by imposing them. So how are we going to understand this idea of forfeiture? So the underlying idea is that we can only claim human rights if we're prepared to recognise others as holders of the same right. So forfeiting must mean acting in a way that clearly indicates that we don't recognise these rights. We don't see others' rights as binding, as imposing binding obligations on us. So this was Locke when he argues that in transgressing the law of nature, the offender declares himself to live by another rule than that of reason and common equity. But his mistake, as I argued, was to assume that any breach of the law amounted to such a declaration. So, for example, Locke thinks the law of nature covers property rights, so that any action of robbing an empty house, say, would entail, on that view, a wholesale disregard of property rights. That's clearly wrong. And in fact, when he's trying to justify wholesale forfeiture, Locke tends to use examples in which one person poses an ongoing threat to another. So he talks about declaring by word or action not a passionate and hasty, but a sedate, settled design upon another man's life. So it's not just a single act, but a kind of an ongoing policy of aggression against another person, of acting towards another person, as though it were the case that that person had no rights of their own that needed to be protected. So can we get any clearer then about when it's reasonable to treat somebody's behaviour as implying this non-recognition of the rights of others? Locke refers both to words and to actions, but words themselves don't seem to count when unless they signal a real and plausible intention to carry out what's being threatened. Merely issuing an idle threat to shoot George Bush or Kim Jong-un or somebody doesn't count if it's merely idle talk. On the other hand, I think we can't just understand non-recognition as occurring only at the moment when somebody poses an immediate threat to a second person's right to life. So imagine Smith has various opportunities to attack Jones, and whenever one of these opportunities arises, he tries to do so. I think you couldn't say that his failure to recognise rights occurs only in those moments when he's actually engaged in attacking. This is the point about a sedate, settled design upon another man's life. So here I think the forfeiture approach does depart from an approach based entirely on the idea of self-defence. The self-defence approaches, I think, run into problems in cases where the threat of an attack comes and goes over time, as for example the physical circumstances of the attacker change. So if the attacker suddenly becomes disabled, then on a self-defence approach, all the rights come back into existence. Whereas I think on a forfeiture approach, the loss of rights continues over the whole period when the person. So on the forfeiture approach, we use particular occasions of attack as indications of a general disposition to violate the rights of the victim. So posing an immediate threat at a particular moment is no longer seen as a necessary condition for forfeiture. So, under what conditions can we say that someone's actions fail to recognise the rights of others? Well, clearly a successful deliberate successful violation is the most clear-cut case. But I think that failed attempts can count as well, and so may taking active steps to put yourself in a position where a rights violation will occur. So, for example, a suicide bomber who arms himself and begins walking towards a crowded market can be disabled, perhaps even killed, on those grounds, since his intention is clearly conveyed through his actions. So we don't take rights away from people just on the basis of intentions, I think because we owe them the opportunity to reflect further and hold back when the moment comes to turn their thoughts into deeds, where the intention is acted upon, and it's clear that a deliberate rights violation is about to occur or would have occurred had not some intervening factor prevented it, then I think we're justified in interpreting the person's behaviour as a failure of reciprocity and his own rights therefore as being forfeit. On the other side of the coin, I think in order to enjoy the status of a rights recognising individual, one needn't hold any particular beliefs about the reasons why one should act in ways that respect the rights of others. So, for example, a person's moral code might be duty-based. She might refrain from murder or theft because she believes that God has commanded her to do this, not because she believes in the corresponding rights of others, or she might be a utilitarian, for example. Yet again, she might be somebody entirely lacking in moral commitment, but who's fearful of what will happen to her if she violates other people's rights. In all these cases, what matters is that the person in question does act so as to respect the rights of others, even though she does so not because it shows respect, but for some other reason, so she doesn't forfeit any rights. Now, clearly, actions may fail to recognise other people's rights to a greater or lesser extent. The right that's breached may be more or less important. The breach may happen on any one occasion or may be repeated and so on. And the action itself may show disrespect just for a particular person or for a whole class of people. And I think our response must vary accordingly. So even cases in which people kill, for example, most often one person will kill a specific other in anger, out of revenge, or for instrumental reasons. Occasionally, a person will go on a rampage and kill indiscriminately. And in between, we have examples where somebody tries to kill people belonging to a certain general category, for example, a serial killer who murders prostitutes, or a suicide bomber who aims to kill people she regards as infidels. Now, it may seem that only in the second and third cases do the person's actions express wholesale disregard for the human rights of others. In the first case, individual case, the killer may try to offer a justification or an excuse for what he's done, trying thereby to deflect the implication that he has no concern for the rights of others. We needn't take these justifications at face value, but nor, I think, should we exclude the possibility that such an aggressor does indeed reciprocally recognise the rights of others and will continue to do so in future, even though in the particular case he's violated reciprocity in the most terrible way. And that possibility should guide us when we think about the degree to which his rights have been forfeited. So as we saw when discussing Locke, it doesn't seem plausible that a person should forfeit all of his rights whenever he violates the rights of others through his own actions. The extent of forfeit has to be proportionate to the extent of the violation. I don't think we can specify this relationship very precisely. I think it's important here to make it clear that when discussing rights forfeiture, we shouldn't be trying to develop a full-blown philosophy of punishment. Punishment serves a number of objectives, including deterring offenders and expressing the community's abhorrence of certain crimes. I think the aim here is only to establish whether and to what extent punishment is permitted by our best theory of human rights. So at the upper limit, we may be able to judge that a certain punishment is so disproportionate to the offence that it constitutes a breach of the offender's human rights. But beneath that ceiling, there's going to be, I think, a lot of indeterminacy over which particular rights have been lost as a result of the rights violating action. And that also extends, the indeterminacy extends to the question of the duration of rights forfeiture. Because we don't want to say that a person who at one time shows himself unwilling to respect the rights of others is to be placed outside the realm of reciprocity in perpetuity. That's one reason why Locke's bestial analogies are so disturbing. They suggest that the aggressor should be removed entirely from the human community. If we start from the idea that human rights depend on reciprocity and can be forfeited only to the extent that the offender's behaviour manifests non-recognition of the rights of others, then I think the conclusion is that forfeiture lasts up until the point at which we have good reason to feel that the offender is now willing to accord reciprocal respect. So we need evidence that the previous disposition to violate rights has been overcome, and this may take some time to collect. Essentially, the offender must have the opportunity to demonstrate that he's now a reformed character. Now, I don't think that the practice of punishment could be governed entirely by this consideration, because there needs to be consistency in things like terms of imprisonment for particular offences. But insofar as existing practice allows flexibility, things like reducing sentences for good behaviour, granting prisoners parole and so forth, that's what a rights forfeiture approach would prescribe. Whereas on the other hand, for example, mandatory life sentences seem to me to be inconsistent with this approach, simply because they deny those who are given them any opportunity to re-enter the human community as a reciprocal respect for the rights of others. So the underlying presumption here then is that every human being is willing and able to recognise the rights of others on a reciprocal basis. That's the truth behind the thought that human rights don't have to be earned. And even in the case of somebody who violates the principle of reciprocity, we should act towards him on the basis that he's capable of rejoining the community of rights respecting agents until we have conclusive evidence that this is not so. And this also limits the extent to which human rights can be forfeited, and also, I'm now going to argue, means that certain of these rights must be treated as unconditional. I'll call these U rights, unconditional rights for brevity. And I think there are two categories of U rights. The first category is procedural. Certain procedural rights are needed if we're reliably to discover what other rights, if any, have been forfeited. So since the underlying thought is that human rights can only be forfeited at all by behaviour that implies non-recognition of the rights of others, we need to be sure that the forfeit has indeed been occurred before acting on it. So that implies familiar legal procedures having to do with gathering of evidence, interrogation of suspects, right to be defended in court and so on. Now, you might think it's somewhat paradoxical that these rights are unconditional, whereas other rights that might in themselves seem to be more valuable to their possessors are not, can be removed. But I think the paradox goes away once you accept that no human right can be removed unless there's good and reliable evidence that the person in question has forfeited it. Now, the second category of U rights are substantive and take first the right to life. So many people, including Locke, thought that this could be forfeited by a sufficiently severe breach of the rights of others, killing especially. But what distinguishes that right from almost all others is that once it's been forfeited and forfeit's been acted upon, of course it can't be regained. So, according to the position I'm developing, before putting somebody to death, you'd have to be convinced with almost complete certainty that that person was incapable of changing in such a way that he could re-enter the realm of rights on terms of reciprocity. How could we know this? We owe every human being, no matter what he or she has done, the opportunity to show that he or she can, after all, re-enter the community of rights. And we oppose the death penalty, we block that opportunity entirely. So here, the argument for an unconditional right to life doesn't rely, as it often does, on a claim about the absolute wrongness of all killing, but rather on the presumption that the person that we'd be about to kill is prospectively somebody with whom we're able to engage on terms of reciprocity. Now, I think another substantive human right is the right not to be physically or mentally damaged in a way that would prevent the sufferer from ever leading a minimally decent life in the future. So since the idea of forfeiture, as I've argued, implies losing certain rights for a period until the person subject to the forfeit is able to demonstrate that they're willing to re-enter the community of human beings fully on terms of reciprocity, the rights that are forfeited can't be rights that it's impossible to regain, such as bodily mobility or sight. And I think included here too would be a right to basic health care, since without health care during the period of forfeiture, there must be a significant risk that the person will lose some of the capacities needed to lead a minimally decent life. And that approach also allows us to see why the right not to be tortured is a new right. Let's assume, what may often not be true, that torture doesn't leave its victim permanently disabled, and think of a case where a person due to be tortured is maybe a torturer himself, so has forfeited human rights to an extent that makes severe forms of punishment permissible. But torture isn't punishment, nor is it just the infliction of severe pain. It involves instead direct assault on the victim's personhood, which it tries to destroy from within by getting the tortured person to collude with his torturer. And therefore I think it imposes a severe risk of undermining the victim's very capacity to act as a rights-bearing and rights-recognising individual in future. So, let me just now retrace overall, just to get the whole argument in place and to conclude. So, I began from what you might call the naive view of human rights, which is that they're rights that all human beings hold unconditionally, simply by virtue of being human and regardless of conduct, which I think is the view that many of us would take at first glance. But if we left it there, it would make nonsense of a good deal of our actual practice. Because even those who hold pacifist views about killing in war would probably concede that it's permissible to punish criminals in ways that would otherwise count as violating their rights. Now, of course, you could bite this bullet too and outlaw most of the forms of punishment we use on human rights grounds. But then I think there's surely something paradoxical about treating human rights as it entirely exempt from the requirements of reciprocity that otherwise pervade our moral life. That's to say, much, perhaps most of our moral behaviour consists in complying with moral rules on the assumption that others are going to comply as well. And that in turn implies that you've got to be willing to do something to sanction non-compliers. So why should it be different when human rights are involved? They after all correspond to some of the most important duties that human beings owe to one another. So we must be very reluctant to violate them, but by the same token, we've got reason to apply heavy penalties to persistent violators. Now, if there existed penalties that were severe enough but that didn't infringe upon the human rights of those who were being penalised, that would perhaps be the best of all worlds. But at the same time, it's not clear to me on what grounds somebody who deliberately violates the human rights of others can complain when some of his own rights are taken away in turn. So in tackling that question, my main proposal has been that once we see human rights as subject in that way to the requirements of reciprocity, we have to introduce and use the idea of forfeiture. So when people act in ways that reveal a clear disposition not to recognise the human rights of others, they forfeit some rights of their own, and the rest of us are released from the duties that correspond to those rights, and in that way practices such as imprisonment for serious crimes become permissible. And I've gone a little way, though I think not far enough, in exploring how forfeiture occurs and how we can judge which rights are forfeited. But at the same time, I've wanted to resist Locke's strong claim that once he's acted in ways that make his rights liable to forfeiture, we can treat the aggressor as though he were one of those wild, savage beasts with whom men can have no society. Whatever the extent of his wrongdoing, this person's still a human being and therefore potentially able reciprocally to recognise the rights of others. That's a capacity we must respect. We don't do that when we torture people or engage in targeted assassinations, for example, that are not cases of immediate self-defence. So, within the standard roster of human rights, whose continued possession, I've argued, should be seen as conditional on the right holder reciprocally respecting the rights of others, there's a smaller subset of rights, some of them procedural, some substantive, that can't be forfeited no matter what.